Welcome back to The Explainer. Today we're diving into a genuinely monumental moment in South African legal history. It's this incredibly fascinating example of how the law isn't just some set of dry rules on a page. No, it's a living, breathing mechanism that can literally freeze a country's entire political system dead in its tracks. So let's dig right into the massive constitutional court case from 2002 that did exactly that, grinding the gears of government to an absolute halt.
So what actually happens when lawmakers fundamentally change the rules of the game overnight, and a court just immediately steps in and freezes those new rules? I mean, it sounds like an absolute constitutional nightmare, right? Well, this is the central conflict we're exploring today. We're going to look at the immense, high-stakes tension between the elected legislative officials who write the laws and the judiciary that interprets them.
To set the scene for you, we are heading back to June 2002 in South Africa. A profound constitutional crisis unfolds, and we're not talking over years or even months, but literally in a matter of days. This wasn't some slow-moving, theoretical political debate. We are talking about legal events that happened at lightning speed and through the entire government, from local municipalities all the way up to the National Assembly, into complete and utter chaos.
Okay, let's get right into it with part one, the anti-defection rule.
So right before this crisis hit in June 2002, South Africa operated under this really strict anti-defection clause. Basically, if you were a member of a legislature and you decided to leave your nominating political party, well, you automatically lost your seat. And looking at the Constitutional Court records, this strict rule applied across the board. We're talking the National Assembly, provincial legislatures, and municipal councils. It was simple. Quit your party or get kicked out, and you instantly lost your job as a legislator.
But then, in June 2002, the legislature decided to completely flip this dynamic on its head. They wanted to relax this rigid rule to allow something called floor crossing. The idea was to make it perfectly legal for politicians to switch their political allegiances, to literally cross the floor of the legislature and join another party without forfeiting their seats.
And they weren't messing around here. Parliament didn't just pass one little minor law. They pushed through a comprehensive package of 4 separate pieces of legislation to make this floor crossing legal across all spheres of government. This package even included 2 actual amendments to the Constitution itself. The president officially assented to these laws on June 19, 2002, and they were published in the government gazettes the very next day.
Which brings us to part 2, suspending the new laws.
The legal whiplash here is absolutely stunning. Check out this timeline. On June 19th, the president assents to the 4 laws. June 20th, the very evening those laws are published, the United Democratic Movement rushes to the Cape High Court with an urgent application. And amazingly, the High Court judge orders the immediate suspension of all 4 laws pending a full review. Now here is the craziest part from the court record. The judge gave absolutely no reasons for granting this relief. Then, on June 24th, a full bench of the High Court upholds that suspension. And again, 0 reasons given. This leads us to June 27th, when an application is frantically lodged with the highest court in the land, the Constitutional Court.
So this entire sequence of events begs a massive constitutional question. Can a provincial high court actually suspend an act of parliament? Just think about the sheer institutional friction happening here. You've got the national legislature, the elected representatives of the people, passing a sweeping package of laws, including constitutional amendments. And then a provincial high court just steps in without offering a single written reason and basically says, no, we're putting this entire legislative package on hold.
This brilliantly illustrates why the Constitutional Court took this whole jurisdiction issue so incredibly seriously. To quote directly from their judgment, suspension of the coming into operation of a piece of legislation has the effect of defeating the will of the elected legislature. The absolutely crucial point we have to understand here is the delicate doctrine of the separation of powers. Parliament's constitutional job is to exercise legislative authority. If a court just arbitrarily freezes a law without a final, carefully considered ruling, it severely hampers Parliament's ability to actually govern the country.
All right, moving on to part 3, a state of chaos.
So, because these new floor-crossing laws had technically passed, you had all these eager politicians who immediately jumped ship and changed parties. But remember, the High Court suspended those laws literally the next day. That meant the old anti-defection rules were suddenly back in force. So members who tried to cross the floor suddenly faced immediate expulsion from their parties and the loss of their jobs. The South African Local Government Association reported that municipal councils were being heavily disrupted by all these threatened expulsions. Affidavits show that shifts in executive control were actually threatened in some areas, causing severe political instability, especially in KwaZulu-Natal. It was just an absolute flurry of urgent, desperate litigation nationwide.
It was, quite frankly, a state of complete political limbo. You've got new laws fully enacted by Parliament, but frozen by a high court, creating this massive vacuum of legal uncertainty. Nobody, from local municipal councillors to provincial premiers, had a clue what rules actually applied anymore. If you crossed the floor, were you exercising a brand new, legally protected constitutional right, or were you illegally defecting and about to be fired?
Let's look at how they tried to fix this in Part 4, hitting the pause button.
So the whole mess finally lands on the desk of the Constitutional Court for an urgent hearing in early July. Now, everyone in the country is demanding an immediate final answer. But the court, they take a very measured approach. They decide that rushing a final judgment simply isn't in the interests of justice. These were incredibly complex constitutional issues, and several intervening political parties hadn't even had the chance to file their basic paperwork yet. The court recognized it couldn't just magically fix this overnight without giving everyone a fair amount of time to prepare their arguments.
Since they couldn't give a final answer right then and there, the Constitutional Court engineered this really ingenious, multi-step legal solution. It's almost like they used a giant remote control on the entire political system. Step 1, they definitively declared that no one loses their seat. Step 2, they hit rewind and ordered that any members expelled since the High Court order on June 20th had to be immediately restored to their positions. Step 3, they froze the executive branches, declaring no shifting of executive control could take place. And finally, Step 4, they hit pause, ordering that absolutely no more floor crossing could happen until the final case was heard. They brilliantly locked the whole system exactly as it was on June 20th.
Now, you might be wondering, why take such unprecedented, sweeping control? Well, the goal, which they heavily emphasized in their ruling, was all about preserving the status quo, preventing substantial prejudice to individual politicians, and avoiding unnecessary disorder. The court carefully and deliberately stepped in to protect the very functioning of the democracy itself. They clearly saw that allowing the political control of a legislature to change, based on laws that might later be ruled unconstitutional, was just incredibly dangerous. By doing this, the court effectively bought the country a desperately needed month of stability. On July 4th, they grant this interim status quo order, and they set a final hearing date for August 6th for the ultimate legal showdown. They gave everyone involved strict deadlines throughout July to methodically file their written arguments, cooling everything down so the law could actually do its job.
Which leaves us with this truly provocative question to ponder. When a democracy's rules are rewritten overnight, is a court's greatest power simply the ability to press pause? The 2002 floor crossing crisis gives us this fascinating, real-world look at the incredibly delicate balance of power between lawmakers who want to change the rules of the game and the judges sworn to make sure the system itself doesn't break in the process. Thank you so much for joining me on this explainer. I really hope this dive into the source material has left you with a much clearer understanding of this historic standoff. Until next time, keep learning,